Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Minor traffic cases can be the worst for this. Believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case. 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those. Since her driving record wasn't bad, when I showed up for her, I found out that she had been driving 70 up an unplowed snow lane, to get around all the others cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did claim she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing, and so by omitting that detail she harmed herself for no reason. At least she took it well and didn't get defensive. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraud committer and has changed identities 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Case as a paralegal. Negligence case. Client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, yeah, I don't know why they charging me with assault, I never touched her. I just threw an AC at her. This is bullshit. Judge rescinded plea deal because of defendant's attitude, lack of remorse. Went to trial and got a year in jail. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. A buddy of mine case as a public defender. A gal was busted on drug charges, and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Little late to the party, but here goes. An obligatory not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing, though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in the sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half-dozen different ways, and each time the COO denied any out-of-work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, but I never had contact with her. It's not like I delivered the flowers myself. COO got terminated for cause so no walk-away package. At her request the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Custody case. Client failed to tell me he was previously convicted of felony child abuse for breaking 16 bones in an infant's body. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months. The thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good. Let's get my kids. Great. That's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working, 2. No longer in apartment, 3. Doesn't want to have a relationship with guardians despite her kids loving them, 4. Won't send her kids pictures of the toys they miss and can't have, 5. Plans on moving out of state, 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant, all in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Client was working really hard to get everything right, and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell as I did my due diligence to make sure things were on the up and statutory requirements were met. Things fell apart very fast apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him asking him to not hide shit from me and to be honest. We go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. Idiot. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence. regardless of if they were granted or denied, swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record, basically finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied, so the one he hired me for was a waste of time and would never be considered at all. Opposing counsel: isn't it true you hit victim in the face with a brick? Client: no, Marcus hit him with the brick. I hit him in the back with a piece of wood. Lawyer: in the UK, I acted for a member of a famous paedophile hunting group. My client was charged with various offences relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defence point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish paedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. He'd sent a photo of his wife's beaten face to his wife with a message saying something along the lines of "This, do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out.